Maine's top election official has now disqualified Donald Trump from the ballot in that state. In the response to your decision, we have seen Trump world attacking you, but you saw Trump himself sharing on social media ways to contact your office, the information to contact your office. I wonder, given the position that you're in and the decision that you've made, if you have concerns for your safety.
We have received threatening communications. Those are unacceptable.
MAGA is furious because Donald Trump has once again been kicked off the ballot in yet another state, this time Maine, after its top election official determined that Trump is an insurrectionist who violated Section 3 of the 14th Amendment and is therefore ineligible to hold office. And reactions have been disturbingly intense. But before we unpack all that, if you haven't yet, please hit that like, subscribe, and the alert bell. All right, folks, we have several clips to look at, but it seems that the recent ruling by the Colorado Supreme Court has triggered some sort of momentum. Perhaps it's coincidence, but there are like 16 challenges right now by various people trying to remove Trump from the ballot, again, on the ground that he's an insurrectionist. And most of the court cases so far, the legal challenges, have been in Trump's favor, at least temporarily. But this one in Maine, I mean, I'm sure the Trump camp is not happy about that because it suggests that there is momentum truly building for this effort. So let's play some of the clips and we'll unpack them together.
Maine's top election official has now disqualified Donald Trump from the ballot in that state, an effort that was underway. CNN's Caitlin Polantz has just read this filing and is following this. Caitlin, what is the Secretary of State saying in this decision here?
Caitlin, the Secretary of State of Maine is saying that Donald Trump is not qualified to be on the ballot in the primary in the state of Maine after reviewing petitions from different people who came to her and wanted to remove Trump from the ballot. I'm still looking through it, but one of the findings here from the Secretary of State is that Trump must meet certain qualifications to be able to be on the ballot, and is finding that he is not meeting those qualifications and thus cannot be on the ballot.
So that's the gist of the argument. And you'll note right off the bat, and as I said in the intro, the process for this is a bit different from as was the case in Colorado. So the decision in Colorado was made by the Colorado Supreme Court. Here in Maine, it was made by the Secretary of State, the top election official in the state, right? So different processes. And so with that in mind, we're going to play some clips from the Secretary of State of Maine, I think her name is Sheena Bellows, in which she explains the process and she argues her legal obligation to have these hearings and to make these determinations.
I think it's really important that people understand the process. As a general matter, states have the power to control their own ballots, and in fact do under the Constitution. And Maine law specifically delegates to me, as Secretary of State, a requirement to review the qualifications for any candidate running for office. So for example, last week, the Superior Court found that my decision to bar Mr. Chris Christie from Maine's presidential primary ballot due to lack of signatures was lawful and correct. So my job, I qualify Mr. Trump for the ballot, and under Maine law, any registered voter can bring a challenge to that qualification. In this case, there were 3 challenges, and I was required by law to hold a hearing, an administrative hearing, to review the evidence, hear testimony. Both sides were represented by counsel. Mr. Trump was represented by an attorney, and then I'm required to issue a decision. That's my obligation under the oath I swore to the Constitution.
So again, there you go. She put Trump on the ballot, but Maine law allows citizens to challenge candidates based on their qualifications. And again, as we've talked about in previous videos, Section 3 of the 14th Amendment is a matter of qualification and disqualification. To be the president of the United States, you have to be, according to the Constitution, at least 35 years old and a natural-born citizen. So whether we like it or not, we can't elect even a very popular 27-year-old foreign national to be president of the United States. The Constitution limits whom we can elect to that office. And yet another one is you can't have, having previously taken an oath to support the Constitution, violate that oath by engaging in or aiding and abetting an insurrection. So it's pretty open and shut as far as Maine Secretary of State's concerned, as far as I'm concerned as well. So again, I want to play some additional clips, though, where she talks about the justification of her decision.
You have decided that Donald Trump engaged in insurrection.
The weight of the evidence brought forward under Maine law in the Section 336 challenge that was brought made it clear that Mr. Trump was aware of the tinder he laid in a multi-month efforts to challenge the legitimacy of the 2020 election, and then, in an unprecedented and tragic series of events, chose to light a match.
And
again, relatively straightforward in a situation, an administrative hearing, again, in which Trump's attorneys were present. They were allowed to present evidence and present witnesses, et cetera, and so forth. So it wasn't like just sheer fiat. The Secretary of State didn't wake up one morning and say, you know what, I'm taking Trump off the ballot. Again, she put him on the ballot in the first place. A couple more clips.
Again, I am so mindful, and I said this in my decision, that it is unprecedented. No Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. But no presidential candidate has ever engaged in insurrection and been disqualified under Section 3 of the 14th Amendment.
Right. Unprecedented action may be justified by unprecedented facts. As far as like the legal scholars are concerned, some have weighed in, but there seems to be robust support for it.
Now that you've read this decision, what stood out to you?
Well, Caitlin, it's a powerful analysis on three fundamental legal points, although it's full of very important holdings. The first point is that as the Secretary of State under Maine law, Secretary Bellows finds she has the authority to disqualify a presidential candidate under the 14th Amendment. That's why we're seeing this variation with Colorado and now Maine on one side and other states disagreeing. It's about the power. That's unique to the states, but her second major holding is not, and it has national implications. That is that the 14th Amendment bars a presidential candidate who engaged in insurrection. I think that's correct, and the majority of commentators agree with that reading, including extremely conservative commentators. The third question is a factual one, and the most explosive of them all. She finds that Donald Trump engaged in insurrection under the 14th Amendment, and she relies on the January 6th committee hearings, and there is a powerful factual basis for that as well. It's a historic opinion by Secretary Bellows.
Yeah, and listen, she's not the first to find that Trump engaged in insurrection. Colorado District Judge Sarah Wallace also took that position. The Colorado Supreme Court also found that he engaged in insurrection. It was the position of a majority in the House of Representatives in the aftermath of the January 6th insurrection. They impeached him on that basis, so clearly they found that Donald Trump engaged in insurrection. And actually, a majority of the Senate, which at the time was under control of the Republican Party, 57 senators, including, I think, again, 7 Republicans, they found that Trump engaged in insurrection. It wasn't the supermajority needed to, convict him and remove him from, he was already out of office, but to keep him from ever holding office again. But a majority of the Senate, the highly polarized Senate, found him guilty of insurrection as well. So there's robust basis for this. Again, across ideological lens, conservative constitutional scholars, Republicans, conservative Republicans, Republicans who voted with Trump, 93% of the time, they have found him guilty of insurrection. Or at least they believe he's engaged in insurrection. So it's a popular, assessment. And yet, this decision by Maine Secretary of State has, met with pushback. So, for example, one of Maine's senators, Angus King, who is an independent, but he caucuses with the Democratic Party in the U.S. Senate, he says that Trump's name shouldn't be taken off the ballot. Okay. And he's not the only Democrat either. One of their congressmen, Jared Golden, he said, I voted to impeach Trump for his role in the January 6th insurrection. I don't believe he should be reelected as president of the United States. However, we are a nation of laws. Therefore, until he's actually found guilty of the crime of insurrection, he should be allowed to be on the ballot. Now, as Anthony Michael Crace, I hope I'm pronouncing that right. I've seen his stuff on Twitter before. He's a lawyer, and he points out, and a law professor as well, that a conviction was never required under the 14th Amendment. In fact, Jefferson Davis, the president of the Confederacy, folks, right, the anti-Lincoln in the Civil War, was never tried for treason. Yet nobody would have denied he was disqualified under Section 3. As I wrote in the New York Times, there were vanishingly few arrests, trials, and lengthy punishments for rebels. So it's true. Imagine Jefferson Davis was never tried or convicted of treason or insurrection for that matter. And yet, do you imagine any of the radical Republicans, which was the name of the iteration of the Republican Party at the time, back when they, opposed the Confederacy, whereas the current Republican Party are replete, they're filled with Confederate sympathizers, but I digress. Do you think they would have said, hey, listen, so that means until he's tried and convicted of insurrection, Jefferson Davis could become president of the United States after the Civil War? Do you imagine they would have supported that? They would have been, no, of course not. And again, as we've discussed in previous videos, when Section 3 of the 14th Amendment was ratified along with the 14th Amendment, it was self-executing. It wholesale hundreds, thousands of Confederates were immediately barred from public office, but they weren't tried nor convicted of insurrection. It was understood at the time to just apply to insurrectionists and not require some sort of criminal burden of proof, charge, or conviction. I digress. Now I'm going to play a couple more clips. And this one here, of course, the Fox Propaganda Network, they're very upset by this. And they raise a question which has been raised many times in the recent past by conservatives and Republicans about what this might do, what precedent this might set.
Ron DeSantis made a very good point, basically calling out this double standard and saying that this is a Pandora's box. What if a Republican were to come out and simply say, because, our current president is undergoing an impeachment inquiry at the time. What if a Republican leader in any state, you name it, decides we're going to take Biden off of the ballot? They wouldn't be able to do that. And if they did, there would be a huge outcry. But when it happens to a former president who happens to be a Republican, who obviously has some issues in the court system, it's a different story.
Trump has all kinds of issues, personal, psychological, spiritual, legal, ethical, to put it mildly. But I don't find this persuasive at all, right? So the idea that we shouldn't do a thing, that we shouldn't uphold the Constitution, or that we shouldn't take any sort of political or legal action, whatever it is, because the Republicans may retaliate in bad faith. If that's the case, we might as well just toss them the keys and let them run the show, period, because anything that Democrats do or don't do could trigger or inspire a Republican bad faith response. That shouldn't really be a consideration. Republicans are welcome to, they are legally entitled to try to challenge President Biden's eligibility under 14th Amendment grounds. I don't think they would have a case there. She talked about, the impeachment. Well, impeachment is not mentioned in Section 3 of the 14th Amendment. It doesn't, fit the criteria for insurrection. But if you want to make the case, you're free to do so. And this idea that that should stop those of us acting in good faith from continuing to act in good faith is insane. It's just a threat. It's the very logic of, how dare you defend yourself against your abuser? What if your abuser hits you harder the next time or abuses you more the next time? It's insane. We would never accept that logic in any other circumstance, and you shouldn't accept it here. And then the last thing I'll say, I thought I had to clip up another clip I was going to say, but I'll end on that note in just a second. So Marco Rubio, the Republican senator of Florida, who is as sycophantic and spineless as Ted Cruz, I almost said Ted Lasso, Ted Cruz and Lindsey Graham, a guy who despised Trump in 2016, but then bent the knee. He said, if Dems are so confident about the Biden record, why do they keep pushing partisan hacks like the unelected Secretary of State, Sheena Bellows in Maine, to kick Trump off the ballot? And I thought this was an excellent response, and courtesy to the guy who wrote it and Mehdi Hassan for reposting it. Marco Rubio calls Maine's Secretary of State unelected because she was elected by the legislature instead of directly by the voters. By that standard, Trump was unelected as president because he was chosen by the Electoral College and would have lost a direct election by voters. Absolutely true. Again, just the hypocrisy and projection that comes from the Republican Party. That's absolutely correct. If the standard is majority rule and direct support from the electorate, then Trump loses no matter what. He lost to Hillary, the popular vote in 2016. He lost to Biden in 2020. That may change in 2024. But if that's the case, Trump was never elected president in the first place. And we technically had a coup in this country because Trump was, he occupied the White House and the Oval Office for 4 years. And by Marco Rubio standards, he wasn't elected. So they're defeated with their own logic because they're so unpopular and disliked and their policies suck and are objectively inferior to those of the Democrats. So I love that dunk. The last thing I'll say, is that the Maine Secretary of State has said that in the aftermath of this decision, and apparently Trump lost his temper and retruthed her office hours and address and all these things. Apparently, Secretary Bellows has been receiving death threats as a result, which is tragic, and it is part and parcel of what the MAGA movement is. Any threat of holding Trump legally, ethically, civilly, criminally, politically accountable for his actions will result in his cult issuing death threats. It's disgusting. It's despicable. It's a unique problem with the Republican Party, and we need to call it out. So anyway, that's where we are. This will almost certainly head to the United States Supreme Court or accelerate the rate at which it does go to the United States Supreme Court. And it's probably not going to stop at Maine. Let me know what you think in the comments.